20 WPM English short and dictation. Be ready for it. Start. Para. Have retired from service with effect from 31 January 1998 full stop if the petitioner was permitted to retire with effect from 31 January 1998. This court fails to comprehend with authority inherent in the corporation to proceed with or continue the disciplinary proceedings or to inflict any punishment upon the petitioner full stop. Para. As noted above, no statutory provision, rule or regulation prevalent in the corporation was referred to or relied upon to sustain the continuance of the disciplinary proceedings after the retirement of the petitioner on 31 January 1998 full stop. Once the petitioner had retired from service, no authority vested in the corporation to continue with the disciplinary proceedings which had been initiated against the petitioner full stop. The retirement of an employee cuts the cord which connects the two entities and severs all relationship of master and servant or employer and employee full stop. The retirement of an employee brings the curtain down upon the relationship of employer and employee full stop. Once this event occurs, no further jurisdiction or authority vests in the employer to inflict any punishment upon the employee thereafter full stop. Even otherwise, the following facts also need to be highlighted full stop. Admittedly, the inquiry report was submitted on 19 February 1998 full stop. A reading of the said report, which stands appended as Annexion 14, clearly shows that the inquiry officer has not recorded his satisfaction in respect of the guilt of the petitioner on the basis of any material or evidence on record full stop. The only conclusion recorded by the inquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings and that from his conduct it is clear that he does not want the proceedings to be concluded, he had no option but to record a finding that the charges stand proved full stop. Para. It is trite law that even if disciplinary proceedings are continued and culminate ultimately ex parte, the inquiry officer is under a positive obligation to record his satisfaction with respect to the charges leveled against the delinquent employee with reference to the evidence based upon which the employer seeks to take action against the employee full stop. Even this rudimentary and settled principle was not borne in mind by the inquiry officer full stop. The mistake committed by the inquiry officer as noted above was reiterated by the disciplinary authority in as much as neither in the order dated 24 April 1998 nor in the order dated 13 August 1999 has the disciplinary authority recorded any independent satisfaction with respect to the guilt of the petitioner based upon the evidence or material on record full stop. This of course subject to the caveat that the failure of the inquiry officer to record his conclusions on each charge is not a flaw which could perhaps have been cured by the disciplinary authority for the first time. Para. Now the question that begs consideration in the light of the submissions advanced across the bar is whether the principles of natural justice were observed in compliance or not full stop. As stated here in above, Rule 81 of Rule 1976 does prescribe observance of the principles of natural justice full stop. From a close scrutiny of the inquiry report dated 29/10/1993, it transpires that the inquiry officer has found the petitioner guilty on the basis of the reply to the charge sheet submitted by the petitioner and other documents, but not a single witness was examined by the inquiry officer in the presence of the petitioner, and also no date, time and place was fixed by the inquiry officer. Full stop. It is not discernible from the inquiry report that the petitioner was never granted any opportunity of personal hearing or cross-examine the witnesses, and in the circumstances there appears. Full stop.